All right, it looks like almost everyone here is in from the waiting room. So we'll go ahead and get started. My name's Keenan Carroll. I work at the Access to Justice office with Pamela Beats. We're grateful for everybody being here for a CLE today. The CLE is a shoestring defense, limited scope preparation and evidence. We have some great presenters here for you that we're really excited to hear from. We have Grant Miller from the Salt Lake Legal Defenders Association. He's the trial attorney there. He's also the former Young Lawyer Division president and was just recently named onto the Utah 40 under 40 list. We also have Kara Porter with us. She is the president and managing director at Christensen and Jensen. She has been recognized multiple times as one of the top 100 attorneys in the Intermountain region, and is consistently listed on the Utah Legal Elite wet magazine as well. We also have Austin Westernberg here with us from Curtin McConkie. He has been their pro bono lead within their firm and always does a great job at helping round up volunteers and volunteering himself. He does a lot of great work on all the different pro bono opportunities within the state. So we really appreciate him. He's also the president of the R.E. Lee Law Association at the University of Virginia's Law School and practices in Curtin McConkie's litigation section. And I'm not going to keep us from hearing from their experience any longer. I'm going to turn the time over to Pamela Beats. She's the Access to Justice Director of the office, so she oversees all the pro bono opportunities that the bar supports through their signature programs. And so I'll turn the time over to Pamela to get us started and to give us a little intro into the pro bono opportunities that are available, and then we'll turn it over to our speakers.
That is great, and I won't keep you too long, but we couldn't pass up an opportunity to talk about our pro bono opportunities while we had you here and why it makes a difference. So, I mean, we all know that when you volunteer, it makes you feel better and it helps the person that you're helping directly, but it also lifts up our community and it gives you some benefits too. So you can gain relevant work experience, you can expand your network. It gives you the chance to make friends with people who are like-minded and have similar interests as you. One of the other things that it does is it really helps you to grow and develop your skills. So you can try out a new area of law and have the access to a mentor or some extra forms or things to help the experience go better. And then lastly, it can really redefine your priorities. It shows you a different view of the world than you may typically see during your practice. So we find pro bono work to be fulfilling both to the person giving it, the person receiving it, and to our whole community. And so the best way to find out current opportunities is to go to the Utah Pro Bono Opportunity Portal. You can access it through the Utah State Bar website if you just click on For Lawyers and then Volunteer Opportunities. It's under the Access to Justice section. It will bring you to a site that looks like this. The best thing about this is it is filterable. It is a one-stop shop. So it not only includes the bar's opportunities, but also from our community partners. So Utah Legal Services and Timpanogos and Legal Aid Society. There's lots of different ways to look and find the thing that fits you best. So we invite you to check it out. And these are a sample of some of the opportunities that our office runs. So if you want to be a part of this, you can reach out to me directly and I'll put my contact information in the chat so that you'll be able to do that. But the ultimate thing that we want to express is there really are a lot of different opportunities. It's not just family law or housing. There are a lot of other things that you can do to help out, and we invite you to check it out. And with that, I will go ahead and turn the time over to our speakers to get into the CLE. And thank you so much for being here.
Okay. Did I successfully do it? Did I screen share? Yeah.
You did, Grant.
Thank you so much. All right, just have to ask. So my name's Grant Miller. I'm a public defender, trial attorney at Salt Lake Legal Defender Association, where I work on felony cases, and I'm very familiar with managing client interactions in very sort of difficult, limited scope situations, public interest situations, and it's one thing that I've come to discover about myself is that I'm still learning after all these years, because it's a very, very sort of difficult area of practice. But I'm hoping I can share some of the things that I've learned with everyone here that can be employed in public interest situations and limited scope situations. You have a lot of clients, you don't have a lot of time. What I want a lot of members of the bar to sort of consider is to take a trauma-informed lawyering approach. Unlike other sort of practices where you might have a little bit of a mellow clientele come in to your office, say, with a contract or some advice on a business plan. There's a lot of trauma involved in public interest situations. People are potentially losing their homes. They might be going through bankruptcy. They might be losing family members. They might be going to jail. All of that is very traumatic. It's all very scary. And so having a client-centered approach to the degree that you can, even though there's very limited scope, very limited time, you don't have a lot of tools, being trauma-informed is something that lawyers ought to start doing more. They don't talk about it much in law schools. A lot of firms don't really think about it too much because we're lawyers. We are trained to analyze law. But social workers are smart when they go into these situations being trauma informed, and we should start learning from them and picking up some tips and tricks along the way. To learn a little bit more, there's a clinical law review article from NYU called The Pedagogy of Trauma-Informed Lawyering. Earmark that later. It's some good reading that kind of helps guides some legal minds in how to be trauma-informed. This is largely a trauma-informed sort of portion, but also is included in this presentation is just a lot of stuff that I've learned along the way that's just helpful, I think, in communicating and easing the fear. Why is client management particularly difficult in public interest situations? It's fear. It's fear. The clients come through, they're scared. They don't know what's going on. They don't know what's going to happen to them. They don't know you, and they don't know anyone else, and they're terrified. And it's difficult, or at least we could take for granted that these people are terrified when they come through, because for us, we're looking very legally at what sort of options we need to counsel them on. It's really easy to miss that these people are putting walls up and they're actually terrified. So recognizing the fear is really going to help you manage client interactions in limited scope situations. There's sort of three areas that require recognition. Recognize that you yourself are a scary lawyer, that your clients are scared of the outcome, what's going to happen to them. And they're also very scared of the system. Hop in with the first one. Recognize that you are scary. You're a scary lawyer. You're a scary lawyer who uses scary legalese. You're in a position of power. They know this. It's scary. Your client has either probably never met a lawyer, or the interactions they've previously had with attorneys have been terrible. This creates a complete trust deficit, and you have to come in from this deficit and kind of dig yourself out of this trust hole to establish trust with your client by recognizing that they're probably very scared of you. A few techniques to kind of get out of being scary and building that rapport with your client. Don't take the little things for granted. Greet them and explain who you are. Hi, my name's Grant. I'm your attorney. I work for you. I don't work for them. I'm here to help you through this. I mess this up all the time because you're so many cases that you have to deal with. And even last week, I walked into court and I just called out a name, the first one on the docket, and just pulled the person out into a conference room and started explaining options and asked them, checked in with them. So like, what's on your mind? And they just said, who are you? And I realized I hadn't even introduced myself as their assigned attorney. So don't take the little things for granted. Things go quickly, but still do the personable things and explain who you are. Set the tone of first impressions and the nature of the relationship. Don't be afraid to talk yourself up. A lot of people just have a natural perception of public interest lawyers as being bad lawyers. Public public interest lawyers are the kind of people that do this because they're bad lawyers that couldn't make money doing something else, or whatever reason, the stupid people that flunked out of law school and had to do the dregs of the dirty work. And they have no semblance of understanding the passion and the culture behind public interest work. And I used to sort of ignore this, but I realized that we really shouldn't. It helps build rapport when your clients know that you're passionate about it, why you're passionate about it, and that you're good at your job. Don't be afraid to say, I'm a good lawyer. This work is important to me. I've got a lot of experience. I'm here to help you. We're going to make it through it. And that puts their minds at ease, that they've actually got someone that they can have confidence in because that person has confidence in themselves. Speak English. Speak English. This might once again seem obvious, but we're attorneys. We like being pedantic. We like using big words because they're descriptive, and in a legal context, they're very accurate and specific. But when dealing with our clients, we have to take a step back and speak in conversational English. Use monosyllabic words when you can. Monosyllabic's a very bad word to describe what it is. But using words that are common, small amounts of syllables, 1 or 2 syllables in the words, will help you be direct with your clients and speak a language that they can relate to that's conversational. For example, FDR, when he did his fireside radio chats, made sure that he only used 1 or 2 syllable words in his speeches, so that way everyone could understand and follow along in his presentations. So that way it wasn't just a totally inaccessible speech. Everyone could understand. Another important thing here, don't assume literacy. I think that we're fortunate that we live in a society where we can take for granted that the vast majority of people can read. In Utah, 90% of our population is literate, which is incredible. But we also take for granted the fact that 10% of our population is functionally illiterate. That means that 1 in 10 people, 1 in 10 Utahns, cannot functionally read. And you have to take that into consideration when you're dealing with your clients. People who are illiterate are very embarrassed by it. They will go to the lengths of the end of the earth to try to avoid confronting the fact or admitting to the fact that they can't read. And it can make very difficult legal situations when you're going over texts and documents that you expected them to read or understand to some degree, and they're pretending like they did when they didn't. The best way to sort of deal with this is if there's some reading involved, go over it. Don't put someone in a situation where you're asking them if they know how to read or expecting them to read. Just make it easy for them so you don't put someone in that bind. I mean, a quick story, early in my career, I had a jury trial, and we had a jury pool of jurors. It was pre-COVID, so we had everyone have the same questionnaire, and the jurors would just answer the questionnaire with a microphone and then pass the questionnaire down. And about 20 jurors in, there's this individual stood up, but he refused to answer any of the questions on the questionnaire. And he was really dancing around having to do it. And we kind of had this awkward back and forth about his, seemingly contemptuous behavior until I realized, like, shoot, the guy can't read. And we called timeout and had a bench conference about it to sort of figure that one out. But don't assume literacy. 1 out of 10 Utahns are functionally illiterate, and keep that in mind in these situations. You'll come across these folks and be mindful of them. Check in with your clients. This one's really big. Ask open-ended questions to kind of figure out where their head's actually at. I used to always ask, does that make sense? After saying a whole bunch of stuff that I'm positive did not make any sense whatsoever. And it's a terrible question. Because it puts someone in a situation where they can either say yes or no. And if they say no, they're going to be in a situation where they're worried they're going to think that you're dumb or something like that. They'll feel stupid by asking clarification questions because they're with an attorney and they have a difficult power dynamic. They're just going to say yes, even when it doesn't make sense. What I've started to do to check in is ask these open-ended questions that allow for any kind of response and also demand a response. A lot of times when I start talking, I want to check in with my client. I just say, what's on your mind? And that'll let me know, if they have got questions at that point, they'll bring them up with me. Or if they've got a fear and their entire mind is somewhere else, like, oh, I'm worried I'm going to jail on the civil matter, that they'll finally come out and I'll, be able to address their concerns. But it gives you a good gauge of where their head's at. You could actually start getting into the meat and potatoes of like what they're actually worried about, and helps build that trust. So ask open-ended questions. Do not ask them if something makes sense. Or if they understand, or even saying like, do you have any questions? Isn't as good as just like open-ended questions that allow them to elaborate what they're thinking about. Empower them. This helps to build trust when you empower them. Let them know that their questions are normal. If someone asks a question, say, great question. I have hundreds of cases like this, the most common question. Empower them to ask these questions. Let them know that this is totally ordinary. Let them know that their concerns are valid. Let them know that you hear them. Just saying the words, I hear you, even though it's virtually meaningless to say, I hear you, like you hear everything. But, people like to hear that, to hear you checking in with them, identify their concerns. Sometimes it's best not to sugarcoat things. Yes, it's going to be a problem, but we're going to figure it out. That's what I'm here for. Recognize those concerns as valid. That's how you empower your clients. Make them feel part of the case. I like to give my clients homework. Usually they'll have to have homework. But a lot of that fear comes from all this stress energy, and they want to have control over something they have no control over. And just telling them, don't worry, I'll take care of this, doesn't help with all that stress energy. So give them something to do. And typically you'll need them to kind of either rally documents or figure out something for you. So don't be afraid to assign that homework and expect them to follow through with it. Real quick, because I'm running out of time here. The other categories that your client might be scared of are the outcomes. Figure out what they're scared of. Usually they've done some kind of preliminary bad legal research on Google before they've spoken to you, and they've come to some strange conclusion in their mind, and they're not going to tell you what it is. So try to fish that out. Try to figure out what they're worried about. They might be losing their home. That might be legitimate. It might not. They might be worried they're losing their kids. They might be worried they're going to jail. All those are concerns that may or may not be legitimate. But you got to know so that way you can address them and prepare them for it. Figure out what they want to do, what their goals are before you get too deep into one side or the other of your litigation strategy. Don't assume they want to fight. Don't assume they want to settle. Don't even assume that they know why they're in court. Get a sense of where their head's at and what their goals are, and then start building a litigation strategy around that to the degree that you can. Clear is kind. Be simple. Be straightforward. Don't sugarcoat. They need to know what's going on, but this will freak them out. So check in with them. It's that trauma-informed lawyering. You have to walk that line of doing your duty as a lawyer, letting them know that they have the information that they need, which is usually bad and not easy to digest, but also check in with them and understand that this is sort of traumatic and they need some help processing it all. Explain their options. Be kind but firm. My experience, you usually have 2 or 3 just terrible options, and there is one least worst option, and people have a hard time understanding that. They usually want some other hybrid option that's in their favor, and that door usually doesn't exist in these situations. So be empathetic, but you also have to be kind but firm with these sort of situations to get through them, because they're difficult. And be positive when you can. Once again, this goes to the homework thing. A lot of that stress energy, people want to put that stress energy into fighting in the system. It's usually a bad forum for what they want. Like if it's like an immediate occupancy, for example, with an eviction, if they're going to put that stress energy into fighting the eviction, it's going to hurt. What they need to be doing is putting that stress energy into finding a place to land. And so be acquainted with the other resources and programs that are related to the field, so that way you can give someone homework, so that way they could turn around and immediately start working on the next step with their life, start rebuilding, so that way they don't have to go back into the system and can move beyond being in the court system. Finally, the system is just scary. Just remind them, acknowledge that the system is scary, that you're there to get them through it as safely as you can, as quickly as you can, and that you're there to help, that you're their attorney. It's difficult. I wish that in these situations there was more time to process these things, give clients space, like true trauma-informed lawyering allows a lot of space, allows for a lot of processing. These situations usually don't lend themselves to that kind of luxury, but to the extent you can, be trauma-informed, pay attention to hesitations, body language, defensiveness. Check in, just say, I notice you look uncomfortable. Is there anything I can do to kind of make this a little bit more comfortable? Like, what's on your mind? Just kind of acknowledge the elephant in the room. It's difficult to get through this stuff quickly, but you kind of have to, don't ignore the warning signs when your client's not trusting you, and check in. And that is the sum of my portion. So I'll yield this back to Pamela for the other speakers.
Thank you so much, Grant. That was fantastic. And just so important to keep in mind, because we all are dealing with clients who are going through these things, and remembering what it's like for them instead of what it's like for you when you've done it hundreds of times is huge. And we can be very scary, even when we don't feel like we are. So let's hear from Kara now. Thank you.
Yeah, actually, that was awesome. I might ask to borrow that presentation when I can convince some of our associates to volunteer. Most of my experience has been with the debt collection type calendars, and I've done those in a couple of different locations. I think probably in front of 3 or 4 different judges, and so this is just kind of based on my experience in that sense. My topic was tell a compelling story. That's not always easy to do. I will say this too, if you haven't done this before, you're going to be scared. I mean, I had been a litigator for almost 30 years, I think, when I first went down to do one of these pro se calendars. And luckily, I shadowed a guy, some of you may know, named Charles Stormont. And because I thought, I don't think I can do this. I mean, no depositions, it's 10 minutes. It's, there's 9 more people waiting to talk to you. And, but I saw what he did, and he was, okay, he talked to them kind of like Grant was suggesting. And let me see this contract and kind of explain to them how the law works, et cetera. It's a wonderful thing if you can shadow someone that's done this a lot. Thank you, Angela. Anyway, so it's kind of hard for someone like me. If I don't have 8 months and 20 depositions, I feel grossly unprepared. So this was something new, and frankly, it turned out to be very satisfying for me to do. Now, how to tell a compelling story when you've got maybe 10, 15 minutes with this judge. You've got about 10 minutes of knowledge with the judge. If you're lucky, the client has some of the paperwork, has maybe, if you're lucky, the contract that was signed, or maybe some of the demand letters, things like that you just kind of have to go through. But not always. A lot of times I'll ask them right off, kind of one of the questions Grant suggested, which is, do you know why they have, asked that you come here to court, or some variation of that kind of do you think you owe this person money? And then that's when you can often find out what their concerns are. Sometimes it's, I signed this, but it was my ex-husband's who should really be paying this. Sometimes it's not really a legal defense. So back to, how do you tell a compelling story in the pro se debtors court? Keep in mind that in most cases, you're going to see this judge over and over and over again. So, and the judge will have seen hundreds, if not thousands, of these cases. So you're not going to get to tell a story like you would to a jury or something. As my client walked down the street, it's really going to be what might persuade this judge to actually rule for my client. Now, if you actually have a good factual defense or a statute of limitations defense or something, hallelujah. But I didn't get a lot of those. So what I have tried to do is maintain my credibility by not making extreme arguments. I will often start, again, the judge is going to follow the rules. But if you are able to make a few concessions, then at least the judge can take that into account if this issue becomes one of credibility. So for example, I will usually, when I'm meeting with the client, I will sort of look for things that they totally agree with. You know, yeah, I signed that, but they never delivered it, or, you know, something like that. So that I will usually try to start off, well, first of all, keep in mind you are responding. When you are defending these, you have to listen to what the other side is saying. Maybe they've actually left something out. Maybe they've conceded something. So you also have to be funneling that in and adjusting what you intended to say. But I will often start with some sort of a concession. Maybe it's mild. Maybe it's not. Maybe the client flat out says, yeah, A, B, and C, but here's why I don't think I owe it. In a lot of cases, by the way, they do think they owe it. It's just a matter of, could I get payments? Or, you know what, I think I owe this money, but my new job doesn't start for 30 days. If I could just have 60 or 90 days to pay this, I'd be fine with it. There's actually a lot of that. And that's where you have a chance to talk with the other attorney sometimes and say, I really think that she's going to pay. Can we, you know, reach an agreement? A lot of them will. Some of them are jerks. I'm just going to say it. So anyway, I will start with a concession of sorts. And, you know, Your Honor, my client agrees that this is her signature, you know, or she agrees that she signed that she had this conversation. You know, I'll do something along those lines so that when I get to the but, I have established at least some sort of potential credibility. And so then when I say something where I actually am arguing, such as, but they never brought the car, or he didn't do the work, or whatever is, you know, the argument, or I told them I tried to return this or turn this, you know, things like that. And then I will just go ahead and explain to the judge the arguments that I think we have. I will usually see if I can spot some legal arguments. One thing that's super handy, of course, is Google Scholar, which, especially when you're doing these remotely, you know, Google Scholar being free, being wonderful, most of the judges use it themselves. And you can just literally type something up while you're, if you're in person, while you're there, you can get on the internet, or you can do it while you're remote, because you may be able to actually pull up the code. I mean, or well, you don't get the code on Google Scholar, you get cases on Google Scholar, which is scholar.google.com. I use that 99% of my legal research, and it's free. So meanwhile, I will have tried to look up some kind of thing, you know, like, well, Your Honor, I think this interest provision may not be enforceable because of X, Y, and Z. It's kind of hard. I mean, in my opinion, Utah has some pretty unfriendly laws. Some of them are extreme. And I remember one, I asked for a continuance with the court because I couldn't believe what opposing counsel was representing to me was the law on a particular type of contract. And this was one of the times that the client was willing to come back. A lot of times they don't want to come back. You know, they've taken off work for this. But it was one time when they said, yeah, I'll come back. I got a continuance. I came back and I researched the law, and it's usually involving their exorbitant claim for attorney fees. And by golly, if they weren't correct, the legislature had done something I thought was, you know, you can tell that I don't like these. You just get people more and more debt. Sorry, soapbox, sorry. Anyway, so you still try to make whatever arguments you can. I do find one of the things that is sometimes compelling is after I've made whatever concession I can that's harmless, and then I've made my but, One of those is lack of proof, because the opposing counsel often does this, they do this constantly every week, and sometimes they are not given all the paperwork they need. And so if the judge, one of the rules the judge is going to follow is if they haven't proved their case, then they haven't proved their case. So I usually listen pretty carefully, and I will say, what we heard though, Your Honor, was, they skipped over the first thing they have to prove, or they skipped over it. Where's the evidence, of this or that, or, it's so it varies widely. But that is something I have found that the judges seem amenable to, if you can just simply say they just didn't adduce this. And then you don't want to alienate the judge or even the other side, because you're going to be up against those same people asking for, a payment plan or something like that. So you have to be a little cautious and not be abrasive about it. But I have had a couple of occasions where they've said, well, Your Honor, I thought I had that in my file. I could get that. Now, if they could get it like in 5 minutes, I'm not, the judge is going to allow that. But if I could get that and come back, I usually say that, my client's taken off his job here, or she had to get a sitter, or something like that. And basically just say, you need to decide on what you've got in front of you. Again, this isn't really compelling, but it's just what you can do under the circumstances. And sometimes there are just pure credibility things where it's something like, I didn't sign that document. Okay, so that's going to be a toughie. I usually have assessed my client as best I can in the 10 minutes or whatever. If it's something that is, he said, she said, and if I think my client, if they persuaded me, or, had a good reason for it, I will sometimes very narrowly, I'll just have my client go ahead and explain it to the court. Ms. So-and-so, can you explain why you don't believe that is your signature? Or just, they're not too picky on the way you word questions. You don't have to worry about your wording most of the time. And then they'll just say, yeah, I wasn't there, or that's not my handwriting, or whatever the deal is. So I will often incorporate that into my so-called compelling presentation, is some chance now for them to hear from my client on some issue of credibility. Another thing that I do try to be compelling is sometimes I've had to make arguments that sound implausible. That's going to hurt me the next 30 times I'm in front of this judge. It's not going to help my client if they think this is a bogus argument. Why is she even making it? So sometimes I will, you're not, obviously the attorney cannot testify, but I will sometimes explain to the judge, because it is informal, why I'm making an argument that basically sounds implausible, but I'm not testifying though. And one example is when I had just in 2 to 3 in a row of them, and I had people repeatedly, I think I ended up having 4 different unrelated people who did not know each other, all at different times, all tell me they literally had not signed this card to sign up for, I think it was one of the gyms, one of the local gyms. And I thought, the first time I heard it, I thought, okay, maybe you don't remember, maybe, but I'll try. But after the 4th time I heard it, I thought and it was all around the same time. I think there maybe have been a scammer out there actually signing people's names to these cards. But I couldn't say that to the judge. I'm not free to testify. But what I did was, I did say, Your Honor, we really need you to focus on this issue of whether or not she signed this. And I said, this is the 4th one of these I've heard for the same defendant. And then I said, I am not testifying, obviously, but I want you to know why I really want to focus on this argument. And so that the judge didn't think, man, she'll just make any argument, no matter how crappy. That doesn't help anybody. Most of the time, then I just make my best argument. Sometimes my best argument is just right there to put the other side under pressure to agree to some sort of payments or something. And, you know, I want to force them to refuse it in front of the judge. So, because my client will often say, I don't have any defense, I owe it, I've got nothing. And I can't come up with anything myself. And so I'll just say, Your Honor, this client agrees that she owes some money. There's just been a temporary inability to pay. And so she's hoping for payments. They don't often have a legal obligation to agree to payments. But I will tell you that the majority of times when the judge says, well, how about it? They'll agree to it. And then it's written into the entry, or we do something, we sign it, that kind of thing. So it's not really a compelling story, but it is a compelling outcome for the client a lot of times. And I think if I'm reading the time right, that I am probably about at the end of mine, but it is very satisfying to do this. People are grateful for the effort a lot of times. If you've done what Grant suggests and kind of explain to them, you know, I'm here to try to help. And sometimes there's not much I can do because the law, I do remember people kind of complaining about the law on occasion. And I would say, you know, you're preaching to the choir. I'm not kidding. Only the legislature can change that. And for some reason they haven't. So that's kind of it. You don't have a ton of opportunity to make your case, but if you start with concessions, if you explain why you're making these arguments, if you have a credible client and you give them a chance to persuade the judge in person why that's not, you know, why something isn't the way it's being represented. And sometimes, like I said, just be straight with the judge and see what you can get. And then the last thing is really emphasizing the burden of proof, because that one I have had some success with that. And that's basically all I can kind of come up with because on the pro se calendars, because they're intense in a good way. It's a good thing to do. So I think that's the end of my presentation.
That's great. Thank you so much, Kara. And it is always challenging when you have limited time or limited resources and there's not a lot of defenses available to get creative and to find ways to reach out, you know, to the other side, to the judge, and use what leverage you have well. So we appreciate your tips and your guidelines and just the practical advice of what it's like. Thank you so much. And now we'll turn the time to Austin.
Thanks, Grant and Kara. I really enjoyed your presentations. My name is Austin Westerberg. I'm an associate at Curtin McConkie, practicing litigation. I ran our pro se calendar, I guess our volunteer program here for a couple of years, and then I regularly participate in that. And I feel very unqualified to be presenting today, but I'm going to do my best to share some of my experiences from the different hearings I've been in. And the topic I was asked to address was dealing with evidence and how to use evidence in these pro bono limited representation type situations. Most of my experience comes from a debt calendar, debt collection hearings, but I think a lot of this advice will be applicable to landlord-tenant hearings and any other type of limited representation. As many of you are aware, this limited scope representation is incredibly challenging. It's different from any other type of, traditional court hearing or court case you'll handle, because you don't get to start from the beginning. Normally you can bring in a client and start from, build your case from the ground up, and you're thinking about things from the beginning and what's going to get filed, what's going to get produced. With this limited scope representation, you're dropped in the middle of a case and you're thrown right in the middle of a lake, and you have to figure out where you are and how to swim and how to get back to shore. And evidence is probably the trickiest part of all of it. So I want to go over 3 steps to using evidence in these pro se cases or these limited scope representation cases. The 3 steps, or what I consider the 3 key parts of it, are first to figure out the universe of evidence. Second is to, how to actually use the evidence. And third is, how to deal with opposing counsel's use of the evidence. So jumping into number 1, the first step when you get these cases is to figure out, what is this universe of evidence? What evidence are we dealing with? A lot of times we'll get assigned these cases 2-3 days before, sometimes only hours before the hearing. And you got to quickly figure out what is out there. The worst thing that can happen in one of these cases is for some sort of surprise evidence to come out at the hearing, or for you to find out there's something you didn't know existed. For example, a couple of years ago, I had one where I represented a client who was in a car wreck, and he said that he wasn't responsible to pay because the car was insured and the insurance company could have paid for it. And so we took this hardline stance of the judge and said, no, my client's not responsible because this car was insured and covered by insurance. And, went out there, made a strong, what I thought was compelling argument, only for opposing counsel to show up with the insurance contract and say, no, your guy was excluded from this contract. And I looked like an idiot, felt like an idiot. We could have got a better outcome for the case if we had known what we were dealing with beforehand. And so that's why I think the first thing is just figure out what's out there, so you know what you're dealing with. I recommend starting on exchange, logging into the court docket and seeing what's available, what's attached as exhibits. That's also helpful to see what's been produced. Maybe there's been some discovery. You'll see some certificates of service for initial disclosures that'll give some hints as to what's out there and who might have documents. From there, I go to the client next, see what they have, what they can provide me. The big thing with trying to get information from a client is to be really specific in what you're asking for. If you give a broad general question like, hey, send me anything relevant, that's not going to be very helpful because they'll surely forget about things or not realize what they have. So I recommend asking really specific questions to them, like, hey, do you have any photos about this? Do you have any text messages? Do you have any emails? Do you have a copy of the contract? Any other letters, things like that? And oftentimes, if they have something, they'll send it to you, and then you can figure out if that's been produced in the case, or if it needs to be produced, or if it's helpful or not. I also recommend coordinating with opposing counsel. If your client doesn't have the documents, opposing counsel are a great resource for providing these documents. They're typically understanding the situation, the client's situation. They understand the challenges of limited representation. And in my experience, opposing counsel are usually willing to send over documents and things that they have. It generally makes the case quicker as well if they just send over the documents to you. So take advantage of that resource as well. So once you get a grasp on the universe of evidence and figure out everything that's out there, the next step is, how do we use the evidence? What's the best way to use this evidence in a limited scope representation situation? In my view, there's 3 different situations where you're going to use this evidence. First is with the client. Second is, off the record settlement discussions with opposing counsel. And third is in court. So we'll address each of those one by one. Using evidence with your client is probably the most important part of this. A lot of times clients will have, a contract or some sort of letter that maybe they don't understand. Maybe they're not as familiar with some of the legalese in there. You can use that evidence to explain to your client what the situation is. Sometimes it'll be a good news. Say, hey, look, you have a good defense here because X, Y, and Z. Sometimes we need to use that evidence to explain to the client, hey, you're in a tough situation. We should look at settling this, or hey, we should approach opposing counsel and work out a payment plan. And the evidence can be really helpful in that situation, especially if a client feels wronged and they're upset and angry, but they don't have a good legal position to argue it. The evidence can be really helpful so that you don't come across as, we don't want to look like the bad guy or that we're trying to help the other side, but if they're in a really tough spot, the evidence can help them understand that. So rely heavily on that physical evidence with your client. Next, use it in your conversations with opposing counsel. So if you have evidence that's not in the record, so if your client sends you some text messages or some contracts that you haven't seen on any of the court documents, you don't think the other side is aware of it, I recommend sending it to opposing counsel as soon as possible. I think it's helpful to get it to them so that everyone knows what's out there, and then you can have open and honest discussions about the evidence in the case. If it's something that you intend to produce, if this is a situation where you feel like you have a good argument, you're going to go to the judge and present the argument, I would recommend producing that evidence to opposing counsel first, giving them a heads up and say, hey, just so you know, we're going to present argument tomorrow, and it's going to be based on this contract or this email. First, I think it's a professional way to handle it so that you can address it beforehand without, wasting the court's time. Second, it avoids potential delays. If you show up in court and present the evidence for the first time where no one's seen it, there's a chance the other side could say, hey, we need to postpone this, or hey, I've never seen this before. It also makes it appear to the judge that you're trying to be sneaky or underhanded. And so I think it's good if you have something the other side doesn't have, to get it to them as soon as possible. Oftentimes in these cases, clients won't be following the rules of civil procedure as you typically would in a case. There's a chance that they didn't produce things by their initial disclosure deadline. They may not have answered properly. They may not, frankly, not know how to produce this evidence or get it on the record. And so if you show up, I recommend doing everything to produce it to opposing counsel and do what you can to get it on the record. Whether it's through a formal filing or supplementation, that's something we typically can't do just for time limitations. You won't have time to file or serve a formal supplemental disclosure, but informally serving it and then having the document ready to go for court is a helpful way to use that document. So in the next step, when you get to court itself, how do we use this evidence? If you have, let's say, a letter that's never been produced, how are you going to get this in front of the judge? In a traditional court setting, if it's something that's been going on for months and months, this would have been produced beforehand through proper means. Sometimes you're just asked to show up to this summary judgment hearing and you need to use this evidence, but it's not in the record yet. I think the best way to do it is just to be frank and honest with the judge. In my experience, even though judges do follow the rules and want to follow the rules as close as possible, they're also understanding of the situation and how, some of the client's resources, they may not have been able to do things through the proper legal channels, through the proper rules of civil procedure. So if you're in a situation where you're arguing, for a motion for summary judgment, you have essential evidence, simply ask the court for permission. You can move the court for leave in that moment, say, Your Honor, we have a copy of a letter that we think is helpful to our client's defense. With your permission, may we share it? The judge, 99 times out of 100, is probably going to grant that request, at least in my experience. And hopefully you've warned opposing counsel beforehand, so it doesn't come as a surprise to them. And so that's one way, if you have a physical document like that, you can present to the court. Another way is to try to get it in through testimony evidence. Again, judges tend to be flexible in these situations. Oftentimes your client will be, on the hearing, on the phone call, and if you have testimony from your client that you think will be helpful for the case, you can ask the court for permission, say, Your Honor, we have, some evidence or some testimony from our client that we think supports this case. May I call him as a witness? Or it doesn't even need to be that formal. Oftentimes the judge will just ask the client directly and say, hey, so-and-so, you're on the call, and then they'll do their thing and ask questions. So don't be afraid to, introduce that evidence in a court hearing, even if it is a less than traditional manner, just because that's just how it goes with limited scope representation sometimes. We have to do the best with what we can in this short period of time. And then another option, if you have something that you want to present to the judge, you want to show to them, and it's crucial to the case, you can also look at postponing the hearing, working with opposing counsel and say, hey, we have this document. We think it needs to be produced. Can we kick the hearing to next week so we have time to formally produce the document? Then maybe look at filing something for the judge, filing a supplemental response with that evidence attached as an exhibit. That's another way to make sure, if you want the judge to see it beforehand, that can be a helpful way to go about it. Again, the filing motion practice isn't always available, isn't always an option here, but that is one way, if needed, that you could help get this evidence on the record. And so the last component of this, the third step I wanted to address, is making the other party use evidence. A lot of times in these cases, and I think Kara discussed this already, You show up and there's a lot of things that are just kind of assumed. Sometimes there'll be a complaint that says, hey, this debt was assigned to so-and-so, and there's this contract that existed, but those contracts aren't attached as exhibits. They've never been produced. It's important, even in these limited situations, to force the other side to prove the case, to make them use the evidence. And it can be an uphill battle for sure. Sometimes when we're called in to volunteer in these cases, there's already a default judgment in place, or the client has some requests for admission they didn't respond to, all these evidence issues that are going against you. But make the other party prove their case as much as possible. Make them show you the documents, make them show you the contracts, prove how it was assigned, and in arguments to the court, highlight those flaws. Say, Your Honor, we have not seen an actual proof of assignment here, or an actual proof of that a contract existed. And by forcing the other side to use evidence, that can be a big benefit to your client. It can also, if settling is something that's beneficial for both sides, forcing them to use evidence can also encourage settlement as well, particularly if there's evidence that they don't want to put on the record. And again, in these situations, don't be afraid to object to evidence if necessary. There's likely not time to file formal objections to evidence or anything like that, but during an argument, feel free to state it on the record and state the objection for it. Oftentimes, the judge, even if that objection is not technically proper through the rules, the judge will be understanding of the situation. Judges want to get these cases right on the merits as much as possible. Obviously, can't totally disregard all rules, but in these situations, judges have leniency to grant leave where needed, including leave for certain objections. And again, if you are making an objection to some evidence, be careful with it. Make sure that you have a legitimate reason for the objection, that you can back it up. You're not just objecting frivolously. So again, those are kind of my recommendations for how to use evidence in these types of cases. My general recommendation is just be flexible in working with these clients and opposing counsel. Be creative, be willing to adjust on the fly. These are just different situations than what we typically see, where we have months to prepare. So be ready to be on your toes, and don't be afraid to ask the judge for relief on behalf of your client if needed. And again, if anyone has questions or wants to discuss anything, please feel free to reach out by phone or email. I'm always happy to chat or take any questions.
Awesome. Thank you so much, Austin. That was really excellent. It was great to just remember that in these types of limited scope representation, everyone is aware that these are pro se people trying to do this without the training or understanding. And that often can be a way to allow the judge to give a little bit of leeway. They have to follow the rules, but there is some leeway to give extra time or to allow them the opportunity to present their evidence or witnesses, or however you need to do it, whether it's through continuances or the steps you outlined. So that was really helpful. We have a little bit of time, so if anyone has questions, feel free to put them in the chat and we can have any of our presenters jump in and respond. So we'll see if we get some questions here.
I do want to throw one other thing in that Austin just triggered in my mind, which is simply when he said, call or reach out for whatever. That also applies while you're doing it. If that's your contacts list can be your best friend. If it's something you haven't dealt with before, but you happen to remember so-and-so did. Hey, Pete, I got a 2-minute question. And if I can get them, most of the time they won't refuse.
Yeah, I agree. Using each other as resources, and even reaching out to our Access to Justice office, we may be able to point you in the direction of someone who could provide the answer for you as well. I think one other thing that I wanted to ask each of you, I'd love to hear from you. What do you think we as attorneys can learn about representing people who are in this situation when we know that they don't understand what's going on, but we also know they don't really have a valid defense and they're angry or frustrated, what would make it better or easier for us as attorneys to deal with them? Grant, you covered it a little bit, but I think it's just trying to do that is really hard when you keep explaining and they keep not understanding. So in any order, feel free to jump in.
I mean, by way of example, you know, I had a client very recently that showed up and he was very abrasive, very abrasive. I kind of tried to walk through what his options were. Once again, not really receptive to anything I'm saying. You know, he's just kind of like, we're going to fight this. We're going to fight this. In this, the case had extraordinarily high stakes, but you know, it's his decision. So we get the wheels in motion for a hearing, and we come back for a hearing, and this is a criminal case, and so the prosecutors were bringing hell or high water with enhancements if we're going to pursue the defense. There were no viable defenses. And it was when I was just sitting in a room with him, and like I use his body language, just, you know, abrasive, and he was just kind of just not, he was not being friendly. He was being very standoffish, and not receptive to anything. And so I just kind of took a moment. I'm like, what? What's up, man? He's like, sorry, I just didn't get any sleep last night. I'm like, why not? Like, what was keeping you up? And then I started realizing, like, what was actually underneath it all was his absolute fear that he wanted the whole thing to go away, and he didn't understand that a settlement can make the whole thing go away without him going to jail or any of this nasty stuff. And he thought that he had to fight it without having a chance of winning. And we had to break down that wall before we could actually have that conversation. I was giving him the information, but he wasn't receptive to it yet. And it's difficult because we're doing our jobs. I felt like I was doing my job. I was giving him raw information, but there's more to it. And like I said, there's every week I go in, I learn more about how to better handle. I mean, there's no magic answer, but it's so difficult because you gotta build trust, and it's next to impossible in these situations to build trust. But it's a necessary component in finding the way. I mean, you're asking the right questions, Pamela, about how you do it. I don't know, but it comes down to a fundamental human connection, and it's very difficult to establish in such a short time.
And on that point, I think, you know, like I mentioned earlier, I think using like evidence, using the contracts or whatever it is you have to show that is a really easy way to do it, to say like, hey, so there's this document they have that shows you owe $1,000 and you borrowed that money, right? So what, I guess, did you pay it back? No, you know, if you really break it down to the simple, you know, this contract says you owe it, we're going to be in a tough spot going to the court because of this contract, you know, leaning on that kind of puts in a situation where they can understand the reality of the situation, and also helps them understand that you're just the messenger that's there trying to help them get out of the situation. You're not the one telling them, hey, you're going to lose. It's like, this is what the evidence says. How do we get around this?
You know, Daniel Crook it just came up, something he wrote, which I think is really good way to end this possibly, where he said sometimes the client just wants to feel like they're being heard by the court. I think the same thing is true. They want to feel like they're being heard by the attorney too. Even if you're saying, you know, well, and I got to admit, because I have issues with some of the debt collection statutes and laws that I think just get into a vicious cycle or I guess vicious circle, whatever. Anyway, and so I sometimes, all I can say is, you know what, I couldn't agree more. I don't think this is fair. Unfortunately, there's nothing I can do about it. And there's really not much the judge can do about it because it is our legislature. I will say that. I will sometimes explain that the judge may not like this at all, but the judge has no ability to go against what the legislature has said in these certain contexts, you know, some of the attorney fee provisions that are such problematic in my mind. So I will kind of do that and just say, I couldn't agree more. We just have to do the best we can do, given what and yeah, I do throw the legislature under the bus if appropriate. I do sometimes. Better that than the judge who probably wishes he didn't have to do what he's doing.
Well, and I think that may be one of the ways, like Grant was talking about, to build trust, to help them understand that it's not that you're not hearing them, you're not understanding their position. It's simply that the law doesn't match it. So I think that's a really helpful tip. And I think that's the end of our presentation. So thank you everyone so much for being here, and to our presenters, thank you so much for sharing your time. This has just been wonderful to hear from you and learn from your experience. So everyone have a wonderful day. Thank you.
Thanks.
Thank you.